Oh, hi, my name is KJ Gehr. I do go by KJ, however, technically, my first name is Kimberly. I just might not answer to it. If you, in fact, call that name out, I might be looking around for somebody else named that. I do specialize in family law here in Jackson County, but I practice law in Josephine County, Curry County, and Klamath County. I have my own practice, opened it in August of 2020 in all the fun COVID times. And as a family law practitioner, I spend a lot of time in court. And another thing I do is I spend a lot of time trying to help people unwind the really bad judgments that they maybe made after the fact. And why I thought it was so great that this is being offered is that when it comes to the general judgment, which is the final document in your divorce or in your custody petition, once it comes to that, in particular, we're talking about divorce, there's a lot of things that judges can't do. So once that judgment is in, the judges do not have the discretion to modify how you dealt with the real property. They don't have the discretion to modify what you did with the debt or to modify what you did with the personal property. There's other things they can do. They can modify spousal support and child support and parenting time and custody, but that's kind of where it ends. So it's really important that what we put into that general judgment actually reflects what you want it to say. And I think that you handed out some general judgments, right?
Yeah.
Okay, did you guys get the one with children or without children for the dissolution?
I kind of handed them out based on the case status that they're working on.
Okay, so how many of you are dealing with dissolutions with children? Okay, we've got 2, and all the rest of you are doing dissolutions without children? Okay, so we're going to look at the one that has the kids in it because it has the most information, but we're actually going to skip to where everybody else in the room, in case you need to leave early, you don't want to listen through all the kid stuff, you don't have to live through it. Does that sound pretty fair? Okay. So I'm going to tell you on your page numbers, like where you need to start if you're in the kid with kid packet. So we're going to start, the first couple of pages are the same between the 2 judgments, and then it goes across. So these documents, they're geared, so the statute changed, 8, 9 years ago, something like that, to redesign all the documents that are available down to, I think it's an 8th grade reading level. I am not overly convinced that 8th graders can actually read through this. I mean, there are times where I'm looking at it going, what are you talking about? But the things that the state is trying to do is to give the biggest generalized picture to try to capture all the things. However, it still misses the mark in a lot of ways. So in your little packet that Melanie put together for you that has kind of the course outline on top, and then it's not the judgment part, but the handouts, I have provided for you some statutory language, and I'm going to tell you where you're going to insert this language so that we can actually be in compliance with the law. I was happy to see that they have actually updated this form as of February of 2023. I had not really closely reviewed that until basically today. So the statutory language that I'm talking about that I've provided, it looks like this. It's kind of, I think, the end of your packets. It's not stapled together. They're individual sheets. One is titled Statutory Language for Inclusion as an Exhibit under, quote, additional provisions. And the next one says to include in the debt and liability section. And the other one is the lovely Quadro, which we're going to talk about, which is basically and wildly ignored in the government provided forms. So this is a bit of a problem. So I decided to give you some language on that. All right, so if you have the with kid packet, or the no kids, we're going to start on the first page anyway. All right, so at the very top of this, you're going to want to make sure you're spelling everybody's name correctly. I realize that seems simple, but it's really important that you do that, mostly because when you go to, I don't know, change your name later, or you want to change title or whatever, or you're going to look up this judgment in the future, if there's an E and an L flipped or something like that, it can be a problem. So you're going to want to make sure everything is spelled right. And I encourage you, just start at the top of the page and then literally look at every single word. We have a tendency as humans, if it has too dense of text, we just skip it. Or we just glance and we're like, we don't need this information. Trust me, friend, This is a document you want to read every single word of because you want to be sure you're not missing something that needs to be done. Okay? So at the top of we're on the very first page of both of them. Doesn't matter which one you're dealing with. So you're going to be walking through this, and it's talking about this document is presented to the court. And then you're going to check one of these three boxes. This is not a section that you get to skip. Okay? So in this section, it's saying either this is a default judgment, and what that means is you have filed the petition, you have served that petition appropriately on your opposing party, and that person has had 30 days to respond, and they have failed to respond. Now, how time is calculated is in fact really important. So we look at it's the day after service takes place, starts your 30-day timeline, and it goes until 11:59 p.m. on the 30th day. So really, it's more like 32 days. Okay? And if that lands on a Saturday or Sunday, you got to wait till the following Monday to actually file. You should, if you're doing this packet on your own, part of that half a ream of paper that is part of all the documents you get in the divorce packet or the custody petition is a default motion and order. So that needs to be filled out. You file that with the court. They can actually be filed at the same time, but I'm not sure how you guys are advising on the timing of that. But so if you're by default, you're going to check the default box. But if you are not by default, do not check that box. And the reason that that matters is because say this thing gets challenged down the road. If it was by default, it's a little bit of a different standard. If it went to a hearing, then it's a different standard. So that's why it matters. The next one down is going to be the stipulation of the parties. Stipulation means agreed. It means the two of you and whoever you are divorcing, have agreed to the terms on this document. It also means you both have signed this document. We will get into that in a second. Well, not a second, but we'll get into it at the end of this. So you can check that box if you both are agreeing and you both have signed and dated the document. And then your third option is, of course, if there in fact was a hearing. Now, hearing is underlined, and this is a general judgment. It actually should say the word trial. The only time you hear the word trial when you deal in family law is when it is the last proceeding at your first look. So it means it's a trial would be when the judge is making the decision on all of the issues, and it's going to end with a general judgment, which is what this is. So you fill those things out appropriately, and I guarantee that if there in fact is a petitioner's attorney or a respondent's attorney, you will not be doing anything with this document. We attorneys will be ordered to, in fact, create this document, and you won't have to do anything. However, it's really funny for the state to include that line, so fill it out the best you can. And then you're going to go into this section about the children who are 18, 19, or 20 years old. Now, at the front end of your petition, when you file your petition, if you have a kiddo who is 18 but under 21 and qualifies as a child attending school, which we'll talk about a little bit later into this document, they have a right to receive notice of this proceeding. And the reason for that is because they actually have a vested interest because they're entitled to child support potentially. So they can waive their appearance, but that has to happen at the front end. So if they waive their appearance here, they can do that, but they have to sign off on that. So you need to basically let the court know, who is this person and are they going to be part of this? And all of this is basically putting everybody on notice. Then we get into the findings. So you're going to see there that very first, it says findings, little a, the court considered the declaration, stipulations, and evidence presented. Okay, so the declaration, that's going to be if this is by default. So think declaration default. If it's by stipulation, that's going to match the word up here, stipulation. And if it's going to be by evidence presented, that means this thing went to court and this information was presented to the judge. Okay, and you need to make sure you mark what that is because that's going to impact when you go to modify this down the road. It could make an impact on what you're going to have to be presenting. I'm sure you guys have all seen this if you have filed your petition for divorce where it says irreconcilable differences have caused the irremediable breakdown of the relationship. You guys have also probably heard the terms that Oregon is a no-fault state. What that means is that we are not required in the state of Oregon to provide a reason for divorce. It is against public policy for people who do not want to be married to be forced to remain married. And frankly, we're a little bit lucky. There are some states that you had to say a reason. Oh, infidelity or domestic violence or whatever. We luckily do not have that. State of Oregon has said, nope, you don't want to stay married. You do not have to stay married. You do not have to be trapped in this relationship if it's not what you want. So that's what that means. And I don't even know why they make it a checkbox, but check the box, right? And then you're going to continue on. There's not a whole lot. It's pretty self-explanatory there in the next sections. And then on this second page, if you're in the kid packet, and also, it's on the first page if you're in the no kid packet, there's this little box that gives you all the reasons for why Oregon has jurisdiction over you. And I think it's interesting that they have a box that says, neither partner lived in Oregon, and the petition was filed in the county here where so-and-so last resided. Another option for people who can get divorced in Oregon, even if neither of them are a resident and have never lived in Oregon, is if you were married in Oregon. That's it. Otherwise, Oregon has to have some kind of claim to you, right? There might be some other state that actually has better jurisdiction. So just kind of note that. I'm assuming everybody here, since you're here on what is today, Tuesday at 4:30, you probably live in the area. I'm going to guess you're not, flying in from Nevada to come be to this little class. All right. So if you're in the no kid packet, you're going to continue through this. And if you're in the kid packet, you're going to jump now to page 8 of the kid packet. All right, so we are kicking off with spousal support. This is an area that often becomes modified down the road. So the pieces that are really important to be aware of is that there are different types of spousal support, which I'm going to tell you about, and that we need to list our factors for why this spousal support is even being awarded and talked about. But there at the very top, it's talking about, is there an existing limited judgment that's in place awarding support? A limited judgment, unlike the general judgment, which is our final kind of nail in the coffin, if you will, the limited judgment is a judgment that takes place before this final judgment is in place. So a limited judgment deals with temporary things. It might be temporary spousal support, child support, parenting time, custody, exclusive use of the residence. It could be an order for personal property to be exchanged. It could be a whole list of things. However, in this particular section, we are talking about spousal support and partner support. The bottom line here is not all limited judgments automatically get placed into the general judgment. It has to be whatever the parties intended. So if the limited judgment gives you spousal support until further order of the court, that doesn't mean that it's going to necessarily be absorbed into the general judgment. That could mean it was going to go to trial and you guys could put on evidence about what needs to happen for permanent support moving forward. But if a limited judgment exists, you're going to check this little box if and only if that temporary support ends at the date of the general judgment and if there's any arrears. So arrears means payments that are still owed to you under a judgment. And that could be for spousal support, which is what we're talking about here, or it could also be for child support. And so this is going to be the amount that's still owed to you. So say your soon-to-be former partner, paid 5 of the 6 months of support, but you still have that 1 month hanging out. Unless you want to forgive that, you're going to need to make sure you mark in here that if there's arrears or if there's not. Okay. So as you go into the spousal support section, you can choose no support, right? There's no support here. Nobody's getting it. Check that box, move on. But if there is support, then you need to say there is spousal support and who is paying it. Is going to be petitioner to respondent or is it going to be respondent to petitioner? This has to be marked so that the court knows what's going on, and more importantly, so the state, if they're going to be enforcing this, knows who they need to go after, right? So when you mark that little box, and then it goes into the actual types. So all of this is found under, you guys have your pins out? Okay. All right. So if you want to mark on your actual judgment and you want to make this little note, I encourage you to do that so that you know exactly what little tidbit I'm telling you. So the statute that is for the spousal support is ORS 107.105. And in that Oregon Revised Statute, which is ORS, that's what that means, you can just type that into Google and it's going to pop you into where the statute is at. Is it fun reading? I mean, probably not. I mean, I think it's fun, but probably not for most people, right? However, it gives you really good insight into what the court actually has to look at when they're talking about what factors are involved in support and awarding support. So the first one we have here on this list is called transitional. Transitional support is specifically and most used for people who need to get back into the workforce and they need some more education. Maybe they were in the middle of their college degree, had a kid, and went out of the workforce, and now they're not done yet, and they need some support until they're finished with their program, or they need job training, or they need to be reskilled. Maybe they were loggers, and now there's no market for that, and they need to go to a trade school to learn welding. Whatever it might be. That is perfect for transitional. So if somebody has been the primary breadwinner and the other person has not been the primary breadwinner and that person is supposed to go sustain themselves, that's a great argument saying, hey, I need time. And this is specifically, I call it the Band-Aid. This is not the thing that's going to keep you safe forever. This is genuinely for usually a fairly short duration of time, a couple of years, to get you through to the next step, whether it's education or work training, skills training, something of that nature. So the things that matter in transitional is if you're going to be typing this out yourself, you're going to want to pull up this statute. And you're going to find the section that says transitional, because across from this little line, it says factors. I've highlighted mine in hot pink. It says factors. The reason this is relevant is because this is the reason, these reasons are going to support you if you need to go modify or if you want to terminate support, whether you're the one paying it or the one receiving it. This is where you look at that list of factors under transitional in ORS 107.105, and you write down, is it duration of the relationship? Is it the work history? Is it the custodial factors? What is it in that section that applies to your situation for this type of support? Okay. So the factors are what would be looked at if anything was to change. Like say your program got canceled and you need support to continue on. You need to go to court and say, I need to have this thing modified. The court's going to be like, well, why was it there in the first place? And if you have on there factor, C2, and it's continuing education, then right there, it's like, well, it's because I had to do this thing. So in the section that says terms, which is the center column, this part is where it's talking about how much and for how long and when. Oftentimes people like to write down how much they want, but they don't really remember to say when's it supposed to start and when is it stopping. Okay, and this goes for any of the categories you're selecting. So the monthly payments beginning at the entry of the judgment. That means this judgment, the general judgment. Our court is luckily pretty quick about once you file the judgment. It has pretty quick turn time when the judge signs and then it's entered onto the record. But your support won't start until this judgment is entered on the record. Or date of service of this petition. This is all attorneys' favorite ones because this means that support is backdated. And it's backdated to the first month after the filing of the petition. So you file this thing on March 15th, April 1 is when that support would be kicking in. That could end up being quite a bit of money in your pocket if, whoever it is that you're divorcing isn't paying attention or is agreeable to that, right? And then the next one is or. And the or, it can be any terms you guys agree to. If this is a stipulated judgment, meaning the two of you have come to an agreement on these things, you guys can agree to kind of whatever you want. The court is not going to look at this and be like, oh, sorry, we don't agree with your agreement. That does not happen. The judges are not looking that closely. They are going to honor what state policy is, which is People are allowed to come to an agreement, even if it's maybe a little crappy for one side and really great for the other side. And then you always want to make sure you put in the ending date. We okay over here? What's going on? Oh, okay.
Keep going.
All right. So the ending date, this is what alerts the court to when the support order is supposed to stop. And remember, you're in the specific category. So if you are doing transitional, it is not uncommon for us to do maybe 2 years of transitional and then move into 3 years of maintenance. And we'll talk about the maintenance support here in a second, because they do different things and their purpose is different. So you talk about your ending date, or you can do by lump sum. Lump sum is a total possibility. This can be paid for out of equity of the house. This could be paid for by, sold their 58 Firebird, and, the lump sum is going to pay off this support proceed. Out of literally the hundreds and hundreds of clients I've had who have paid spousal support, I think I've had 2 ever who've wanted to pay spousal support. So a lump sum is sometimes a nice choice for people who don't want to be writing a check to their ex every single month, right? So then you move on to compensatory. Compensatory is pretty rare to see, mostly because it has really specific parameters. Compensatory, the best example to give for this is when you are the one who stayed at home to support, you're the one who went to work while your partner went to medical school, or got their real estate license, or went to law school, heaven forbid, or they did whatever to get this higher earning capacity. And then as soon as they're successful, you get dumped. And you're like, whoa. I'm sorry. Nope, I paid my dues here. So compensatory, it's basically a way to repay the efforts and energy that the one partner did to the success of the other partner. It also happens to be one of the only spousal supports. In fact, it is the only spousal support that can be non-modifiable. So if you have a compensatory award, that means that person cannot go back to court and say, oh my gosh, I lost my job and now I can't pay. The person will be like, yeah, too bad. It has to be really extreme circumstances for compensatory to be modified. That's actually probably one of the reasons why we rarely see compensatory. But if the scenario fits where you broke your back for 6 years while they were doing their residency, and then now they finally got that big wig job with the Mayo Clinic, and you're left holding the bag, this could be a really good option. And again, you're going to make sure you fill out your terms, and then you're going to look at that statute and select the factors that apply. Okay? And you'll notice in the statute that there's many factors that overlap. So the transitional support basically is kind of the baseline factors that you're going to see reflected in the other 2 types of support. The other ones just have some additional detail to add in. Okay, and then we go down to maintenance. This is probably the most common support that we see. So maintenance support is, I'm sure you guys have heard the adage of, to maintain the lifestyle I have grown accustomed to. That can mean that you get to go on vacation once a year. That doesn't have to mean that my facials still happen every single month. That it doesn't have to mean something posh and fancy, right? It is intended to help people maintain a lifestyle that's within view. I always describe it to my clients as like, I can look at what I used to do. So if I used to take 3 trips a year and now I can only take 1 trip a year, that would be appropriate. Because the goal of spousal support is not to equalize the income of the parties. That is not the goal of spousal support. It's also not punitive, which means it's not meant to punish the person that is going to be your ex. It's not like yeah. No, it is genuinely made to support a person until they can become self-sufficient, which is what the court's goal is, and it's what the public policy of the state is. The state wants everybody to be able to be self-sufficient and not continue the entanglement of support. But sometimes that isn't appropriate. Sometimes indefinite support is appropriate. So in the maintenance support, you're going to see factors like not just duration of the marriage, but also the lifestyle they've become accustomed to. You're going to see things like resources available to the parties. That could be, husband's able to borrow against his 401k. Wife won't have that opportunity. having credit available to you. So imagine you're the stay-at-home wife and you don't have a lot of credit because you haven't needed it, or you've just always been kind of the tack on to husband's credit card. All of those things are possible. And so your credit might not be great. You having an opportunity to refinance a house in your name is really minimal. But banks, they will look at things like spousal support awards, and that is viewed as income. So there's a lot of reasons to have spousal support. Make sure your factors are in there, because there's a lot of positive things that can happen to help facilitate becoming self-sustained and moving forward. Okay, this section, if you are doing spousal support, it absolutely needs to be filled out. I cannot do crap for you. If this is not done, and then we have to make up why the heck things happened the way they did, it makes it very challenging for your future attorney down the road when things go sideways, which hopefully they won't, but they might. Okay. So we're going to flip to our next page. And I was so happy to see that this newly modified in February version has place of payment. So the place of payment is important because this is a new modification to the statutes that are saying that we need to tell the state if they're going to be taking charge of these things. So if you have just the dissolution packet and you have no children, Jackson County and the state, they will not enforce, they will not collect spousal support for you. It has to be associated with other things unless you're on subsidy. Like if you are getting cash assistance like TANF, they'll collect for you for getting TANF. And then that's pretty much it. If it's not linked to child support or you receiving other state cash assistance, the state will not enforce the spousal support. So don't waste your time applying for it in that way. Get creative on other ways to collect. Okay. So if you are in that little section, you're going to see that there's a couple different ways you can do it. The first one is the state collects it. If that's an option, I always suggest that people do that because they enforce for free. They're not charging you for sending letters to your ex, reminding them to pay their stupid support award, right? They're going to do it. The next one is that you can actually have payments direct deposited into a bank account. So whether you're the one paying or your spouse is the one paying or your partner, whoever, either one, you can select to have it just go directly to you. If you want to skip the state step, then that's fine. And also know if the state is collecting, if you do have, subsidized support of some kind, the state is going to take a chunk out of the support you're receiving, put it in their pocket to help repay them for the expenses that they're making, and then you're going to get a portion of that. So you might think, oh my gosh, I'm supposed to be getting $1,500 and I'm only getting $1,200. This guy's shorting me. Actually, it's the state taking their piece if you have subsidized things that you're enjoying in your life. So that's something you can talk with child support about with the percentages, because I don't know what the percentages are that they take, but just be aware of that. So in this section, you're going to want to make sure you choose how you're going to be collecting this money, directly to you or if it's going to go through the state. Then the withholding, where it says withholding, this is only an option, again, if you have child support or if you're receiving state support. So the withholding is not an option if you are just getting spousal support and you don't have those other things going on. Okay, so if you're in the kid list packet, on to life insurance. Okay, so get your pen out. So this is another statute you're going to look at. This is ORS 107.820. This is one of my favorite sneaky statutes to argue. I love it. And I love it when the judges go, I've never had anybody argue that before. Yes, I found one. All right, so life insurance. A support order is an insurable event. What that means is that you have a right to protect your interest in spousal support, retirement benefits being paid out to you, and in child support. So the life insurance piece basically says you, payer, need to have a life insurance policy and an X amount of money that is sufficient that if you predecease this order being done, that it's going to pay me. So you get to write in your own number My default number is 250,000 because those policies are fairly inexpensive to get to and is actually enough to cover things like, I don't know, braces for 4 of your children and broken legs from little Timmy, right? So this provides you the option of neither party is ordered to carry life insurance to the benefit of the other party, and the other one is that you need to carry this benefit. So this is talking about basically how much you want to have, but it doesn't give you more information. It says, okay, here's what the coverage is supposed to be. The paying party, paying the support must provide, there's a true copy of the policy, all of these things. This is so many words. Most people have stopped reading by like line 2 and don't really realize how powerful this little section is. So these kinds of things make a difference fairly quickly, right? Of if this suddenly becomes important to you, you're going to be really happy you check this little box and put that number in there. Because what this doesn't say is that if the party doesn't do this, this can give you grounds to make a claim against their estate because they should have done it and they did not do it. Might be a little intense, you might be a little sticky, but you in fact might be able to enforce this even without the language that I put into all my judgments, which says this will happen if you don't have a policy. So that life insurance piece, you have an insurable interest. The other fun thing about that statute is that say that your former spouse refuses to carry a life insurance policy, won't agree to it, and you're like, fine, that's fine. Guess what? You can still take a policy out with them. And you can ask the court to order them to go and have a physical examination in case that's required. You can do all those things because you have an insurable interest through your support award. Okay. And not just support, also retirement benefits. So it might not be a spousal support award. It can be things like half the 401k or the 403b plan or PERS, whatever it might be. Okay. So the life insurance piece, don't skip those boxes. We need to know what you want to have happen. There isn't just a default button. It needs to be said what the plan was. Okay. All right, coming back to our kidless one, we're now into the property and debts, my favorite section, mostly because it's the most impossible to help people with after the fact, right? So we need to make sure that we are reading each line, we are checking each box that needs to be checked, and that way we can make sure we know. So I've already just explained that the court lacks the authority to modify and kind of unscrew what may have gotten screwed up in the general judgment. Okay. So if the court doesn't have the discretion to do that, you're sort of left holding the bag and trying to find a different path forward. All right. So the very first one on here is real property. Real property means real estate. Sometimes people get confused by, well, it's property. Well, yes, but property can mean personal property also. So if it is not land, it is some other kind of property. Land is real property. That's what real estate is. So you're going to mark the box. Either neither party has any interest in Oregon or any other place. I love that they said it. Or any other place. Just anywhere else on the planet. None for anybody. Or you go down to both parties have, or you can just check petitioner or respondent has an interest in real property. You are going to put the address. Okay, not just Jackson County, Oregon, or Merlin. None of those things are helpful. We need the address. And then that little check, in fact, I did 2 asterisks and a hot pink highlight. This is how important this is. That you check that little box that says this property is awarded as follows. You can literally attach any number of pages that you want to this. That's perfectly fine. However, bare minimum, you need to say, what is going to happen with this property? Are you going to continue to own it together as joint tenants? Are you going to be awarded the property and you get to have exclusive use of that property? Is your soon-to-be former partner going to instead live at that property and then pay you out? What is going to happen? Okay, I wish that judges, as soon as they saw a checkbox that there is property and a blank line, I wish that they would reject every single judgment that came across their queue, but they don't. they just might not see it. It's not, they're trusting that people are reading through these documents and in their best interest filling these things out, right? So they're not going to just micromanage the bejesus out of this thing. You have to do it yourself, okay? So on this piece, you're going to say, here's how this property is awarded. And then you line it out. I'm going to get $10,000 out of the equity of the house, and he's going to have this much time to do it. Or she's going to give me half the equity out of the house, and she's got 185 days to get it refinanced. But then what? It's the then what. If our best laid plans don't work, what are we going to do? Okay, so think about if you've got property and you put in there, he's going to buy me out in 180 days. What if he can't buy you out? If he's unable to buy me out, then the house goes on the market. Well, with who? And at what listing price? And when do we do a price reduction? So the things you need to be thinking about is, if plan A does not work, what is plan B? And if plan B doesn't work, what is plan C? Because we have a mortgage that still has to be paid. We have utilities. We've got property tax, homeowners insurance. We have things that are happening in real time, even if this property is not selling and we need it to sell. Who's on the hook for those things, right? So this is the kind of stuff that gets missed because people are done, right? You're fried. You're tired of thinking about this. It's emotionally exhausting. However, it will become incredibly more exhausting when this goes sideways and there isn't anything that us attorneys can do for you. Okay? So think about this document as ways to save yourself between $5,000 and $40,000 in attorney's fees of unscrewing what didn't get done because you were tired. Okay? And I realize that that's a little bit harsh to say, but it is just so the reality. Okay? So in this section, it talks about the legal description of the property is attached. You see how there's a box there. Really, it should be no box. It should just be like, this thing's attached. So I had Melanie, I sent over to her one of my favorite handy dandy resources. It's in your packet. This is Jackson County Front Counter. This is a website that is provided by Jackson County. And you can just put into Google Jackson County, Oregon. Don't forget Oregon, or else it'll end up in Georgia or Mississippi, and that's not useful to anybody, right? Okay. So Jackson County, Oregon, front counter. It's going to pop this up. This is not actually the home page. There is a page in front of this, and you're going to click the box that says Property Information Online. You click that box, and then you're going to get to this page. And from here, you're going to click Address. And then you're going to pick your assessment year. It's always just defaults to the year, the most recent assessment year. And then you're going to put in this one was set for map and tax lot. Most people don't have that information. So click the address one, and then it's going to say house number and street. Some little pro tips here for you. This program does not like the word west or south or north. So start with the journal name. So if you're on East Evans Creek Road, it might be E. Evans, it might be Evans, or it might be East spelled out in Evans. So if you know that this is my address and it's not popping up, start playing around with what it says there for the street name. The value of this is that this is going to get you to a copy of the deed. Okay, this deed contains your legal description. The legal description is what tells us exactly which parcel we're talking about. Because a lot of times a street address might not be, in fact, be correct. It might be, maybe there's been two houses and it was divided, and one of them kept the original address and the other one now has an address that's for the street behind them. I mean, weird things happen. So what this does is that it makes no mistake to which property is in fact being transferred. Okay, so on this, where it says the legal description of the property is attached, you are going to get to the next page after you push in your address and you hit search. You're going to see yours or your spouse's name. You're going to click where it says account info. Click that. It's going to pop up this other very archaic looking page, and you're going to see sales history, deed, and you're going to click that link, and it's going to load up your link for you, and it's going to pop up the deed. Okay, you just hit print on that, and then that is what you're going to attach as an exhibit. And we're going to talk about how to get your exhibits to actually be stuck to the judgment. We'll talk about that in a little bit. Okay, so you're going to mark your exhibit. You're going to put it attached to this. Okay, do not forget to do that. And then it goes on to the next section, which you also aren't going to skip because you're good kids and you're paying attention, where it says who is going to be preparing the documents to transfer this property. Okay, so who's going to be responsible for that? If it is a parcel of land here in Oregon, we have several different types of deeds that are available. However, in the divorce process, we can use fairly risky ones like the quitclaim deed. A quitclaim deed is, I call it risky because whatever is on that land, liens, easements, whatever might be encumbering that land travels with that deed. So if you quitclaim a piece of property to somebody, they're like, okay, great, I'm going to take it with all the risks. Whereas other types of deeds like warranty deeds or bargain and sale deeds, those things have been cleaned up. Those things are gone. You have a lot more assurance that, oh, there's not going to be scary things attached to this thing. But quitclaim deeds, yikes, watch out. But in this situation where it's one spouse deeding their interest over to the other spouse, quitclaim deeds are perfectly fine. Okay? So the quitclaim deed, somebody's going to have to figure out who's going to prepare that. And then they need to actually go record that deed. This is always the fun one. They're like, well, I swear I did that. Yeah, well, the county has no idea. So your spouse is still on the hook for all of these tax liens and all of these things that are going on. Your new child support judgment that's up against you, that attorney's fee that you didn't pay, and now it's a lien against the house. These are all problems. So whoever is responsible for doing this, that last word there, recording of the deed, that piece you need to make sure that happens. So that means they're physically either sending it in with the fee or they're walking it in to, I'm pointing over here because that's where the Jackson County clerk's office is. But go and get it actually recorded in the county that the property exists in. Okay. And then you see the thing other. You can kind of do whatever the hell you want to. Is hell still considered a swear word? I hope not. Okay. Hopefully not. But you can write in whatever you want to have happen with the property in that other line. You have to remember it needs to be possible, right? So don't make it so complicated that nobody's going to be able to follow through with this thing, because then you're going to be back at square one as if you never filled it out. Okay. So I don't think I provided in the language. I did not. Sorry, I didn't give you suggested language for property, but things to put on your bullet point list is if option A is that one of you is going to keep the property and then pay out the other. What that actually means is if that mortgage is held in both of your names, that means they are taking you off the mortgage. And usually the only way to do that is through a refinance. So that means taking you off that mortgage so that you're not on the liability anymore. And then you're getting a portion of the equity of the property. So if that's what your option A is, how long do they have? Timeline to do a refinance. Timeline to get paid out. Okay? If your partner or you can't qualify for the refinance, what are you going to do? If the option is put the house on the market, great. Win. So the types of language I put into my judgments is as soon as they find out they can't qualify for a refinance, the house is on the market within 30 days. And it needs to be listed with a qualified agent. So you've got a lot of people out here who are willing to just put it for sale by owner at a price that they know will never sell, and then they just continue living there and like, well, I'm fulfilling the judgment. And yes, of course, this has actually happened. Of course it does. Okay. So if the house doesn't sell, then what? How long are you going to leave it on the market? When are you going to do price reductions? Who gets to choose how much the price reduction is? So the types of things that you can do are a 5% reduction every 90 days until the house sells. You can do price reductions at the advice of the agent. How do you pick your agent? You guys can select it together. If you can't make a choice, you take your 2 top favorites and then make those 2 people pick one for you. I mean, there's a lot of ways you can do it. But a lot of times it's the what if that isn't really thought all the way through, and people find themselves in trouble. The other piece of this, which is not on this document, is called exclusive use of the residence. This is going to be exclusive use of the residence. So this means, does one of you get to stay living at the house? So if one of you is going to stay living at the house while it's maybe up for sale, those terms need to be talked about. You need to keep it in market ready condition. You need to make sure it's available for showings. None of this, oh, sorry, I'm not available, and then the house never gets shown, right? So when you're thinking through, okay, he's going to stay in the house, but I know he's a total slob, it might not be to your advantage to let him stay at the house. And then who's going to be paying the mortgage during that whole time? And utilities, taxes. And it really is the sky's the limit on what kind of deal you want to make on that. You know, it can be anything from the person who lives there pays for it. They can't afford to pay for it. Then the other person gets to live there. I mean, the list is really long on the things you can do. Just think through that, though, because that's real money that really has to be paid. All right, moving on to personal property. So I had sent over to Melanie, this is in your little packet. I sent over to Melanie an asset sheet that is appropriate to be attached to the judgment. And then there's also one that the state does that they have, which is the statement of assets and liabilities. Okay. Yeah, they're probably in the packet together. So they basically cover the same kind of things. However, under no circumstances provide account numbers. You can just say where the bank account is at and the last 4 digits. You can just say where the bank account is at. Like, it's okay to not be specific, because this is intended to where you can actually file this with your judgment. You can make this into an exhibit. Okay, so let's go to the actual language of what this is talking about. So in the personal property section, it's talking about, here's these things that gives us the options. First one is, we've divided all the personal property that they've owned separately together, and each is awarded those items now in their possession. So what if your jerk ex decided to take all your stuff while you're out of town visiting your mom, and now you've had to replace every single thing in your life because he took even the extension cords? But he now gets to keep that stuff because he took it? Like, what? So you need to actually read through this and make sure that it reflects what you really want to have happen. If there's things you want back, or there's things that your soon-to-be former spouse is wanting, those things have to be discussed, because it becomes incredibly challenging after the fact to get stuff back. Not to mention, things walk away, things go to the pawn shop, things suddenly become the Saturday night party, and it's gone, right? So on this section of the judgment, you're going to see that little section that says except that, and then it's going to go into, here's what the petitioner is awarded in personal property. Personal property is every single thing that isn't a piece of land. That includes bank accounts. That includes retirement accounts. It includes your doll collection. It includes your gun collection. All of those things are personal property. So you're going to, if you have some sticky items where you know that, say you've got 2 sets of couches, you're going to want to specify the brown leather couch to dude, the red leather couch to me, whatever it might be. And you can do that by attaching an exhibit that gives you a lot more space to break that out. You do not have to put estimated values on these. We're going to go into why that makes a difference. But if you're to go to trial, you can use this in trial. This fulfills the circuit court, the uniform trial court rules for the joint asset list that needs to be presented. But It's useful in this scenario where we're dealing with the judgment because there is just a single line for a whole house of stuff. Like that doesn't make any sense. So having more options to be able to increase what's in there is great. So you can attach it as an exhibit, and you're going to talk about the next one down, which is the petitioner is awarded all retirement benefits and pension plans and profit sharing and this and this and this. Past employers free of any interest of respondent. Okay, so this is the only reference that we get to have to retirement, which for most people, aside from their real property from their house, is the biggest investment that they have. It is their one option that they have going on. Let me show what's going on. So it is a little bit of a disservice for the state to provide us like this really piddly little thing where you get to check a box when this could literally represent hundreds and hundreds of thousands of dollars. Okay, it's sometimes millions of dollars. So I've provided you some suggested language, and you're going to see at the top it says suggested language of needing a qualified domestic relations order. Okay, what this is. So this judgment, the purpose of it is to say who gets what of the retirement, right? Maybe it's the parties are going to split this thing 50-50. You can put that onto your little sheet. You can say Edward Jones, last four digits, 447, 50% to wife, 50% to husband, or wife and wife, whatever the combination is, right? You can do that on this sheet, and that will provide instructions to an attorney who specializes in drafting a qualified domestic relations order. So what this is a document that happens after the divorce is done. So that means the general judgment has been entered, and then a secondary document called a supplemental judgment is going to be created by somebody who does this for their profession, because my eyes want to be like poked out of my head imagining doing this kind of law. So that person is going to write specific instructions on what is supposed to happen depending on what type of account is being split. And as you can imagine, there's a gajillion types of accounts. You've got everything from pensions that are from unions all the way to PERS. We've got, we see a lot of CalPERS. We have military benefits. We have private investment firms. We have everything from cryptocurrency all the way to, non-vested stocks. Those things all these things have value, but how you get to them is really specific depending on what they are. Our little document here that has a checkbox isn't going to be real helpful if you actually want to get part of what those things are. So a Quadro, this secondary document, which is a supplemental judgment, gets drafted. You provide your information to these attorneys. I gave you two names there at the bottom. These are two that we see all the time. I use Clark Williams, but Stacy Smith does good work too. So I provided you those two names. They're not local. I don't know of actually any local attorneys who do Quadros. But what this does, this language gets inserted into your general judgment. And what this does is this gives instructions to the drafter of your Quadro. And it also provides rules. Because imagine if your soon-to-be ex is not real freaking stoked that you're going to get half of the 401k, and she decides to go out the day before this all happens and withdraw a bunch of money from it so that it looks like half is way less. Yeah, well, this kind of stuff protects these things. And so what's going to happen is this gives rules to you're not to do withdrawals, you're not to do anything that diminishes or reduces the value. That's not just market forces, right? So that's what this language does. It also, this little handy dandy duty here at the bottom, this retains jurisdiction. This little statement tells the court, we want you, dear court, to retain jurisdiction of this issue to make sure if something goes sideways that you can help me fix it. So I don't know if this jurisdiction language has been challenged at the appellate court level, but I certainly have used it and it's worked like a charm at the trial court level and it hasn't been challenged. But because going back to the property issues that can't be handled by the judges after the fact, this gives the judges an opportunity to take a crack at the apple if something goes sideways. Okay. So you're going to want to make sure that if you have retirement pieces involved, that you have an understanding of how this is going to be split. The value of the Quadro is that this does not mean you have to do a distribution. Distributions are costly. They cost fees, there's taxes, there are all different kinds of penalties if you are not of the age bracket to in fact be withdrawing from an account. The Quadro splits that with no fees. The Quadro splits that into a new retirement account that matches the same one that it came from, totally separate from your ex, with no taxes. Okay. With no taxes. So it's super important that if you are going to be doing a splitting of accounts, that you use the Quadro. Otherwise, you're just going to get hammered on taxes, cap gains. It's going to be a real pain. So don't do that. Okay. All right. I got to speed up. Sorry. All right. So moving on to my next favorite section, which is debt. Okay. Lots of marriages fall apart because of debt. And heaven forbid, if in the divorce, you, dear one, are stuck with the debt, right? Okay, so on the debt page, you can always add additional debts. So you do not need to say what the debt is for. I mean, I guess if you really want to, you can, but you don't really have to. Most of the time, it'll be pretty obvious if it's, Visa credit card. Okay, debts for things, whatever. All right, so you're going to say who the creditor is. If you want to say what the debt is for, that's fine. And the amount that's owed. And this is a little bit of a sticky wicket, meaning how much is owed when you calculate that is up for argument. And the argument comes in this bottom section down here. So in this paragraph down here, it talks about the debt as of the date of separation. Oh, wait, or is it the date of the dissolution trial? Oh, wait, or is it the date that we're drafting this document? Like, which date is it? So that's something, if you're doing a stipulated judgment, the two of you are going to have to agree on what date you're selecting. Certainly, date of separation is one that does happen. However, that's not what matches case law. Case law, it's the date of the actual dissolution trial. So depending on where this goes, if you do end up in trial, you are going to want the court to decide what date is being used. And then you'll just put in whatever the court ordered for that date of separation of the debts. You're going to then put that amount into the amount section because that's what's actually going to be enforceable. Okay. And then you need to say who's going to pay that. I highly, highly recommend to all of my clients and to everybody in this room, pull a credit report. Pull your credit report because it's going to have things on there that you maybe thought were paid off or that you didn't know were in your name or that you were told didn't exist. And in fact, here they are. If they are in your name, you are on the hook. Okay. So pull your credit report. In fact, I suggest everybody do that like tonight. Pull your credit report. That way you can just make sure that anything that's outstanding, you guys can talk about. And if you happen to be with somebody who has a spending problem or potentially a gambling habit and you have children, please pull your kids' credit. Okay. So I don't want to put the fear of God in anybody, but it is possible to take credit out in children's names with their social security number. So just make sure that everything is copacetic. Okay. So pull your credit report, make sure everything is on there. The debt being awarded to that person does not mean you are off the hook. Creditors will come after you, even if it's not in your name. You're married to this Yahoo, too bad. You used to have a card in your name. You haven't had the card for 15 years, don't even know where it is. Too bad. Creditors will come after you if they think they can get money from you. So what's missing from this little handy dandy little section is language I provided in another handout. So this is language to help protect yourself. Okay, so this is not necessarily statutory language in some sections, and the other of it actually refers to federal law. So what this language is, it's saying what the rules are. That neither of you are going to charge on the credit of the other without permission. It's saying any outstanding joint credit cards are going to be closed and shredded. And then it talks about what happens if one of you doesn't actually pay the debt you were, quote, awarded on your little sheet. What do you do? If a creditor is coming after you and you choose to pay that amount, what resources do you have? What recourse do you have? And so that's what this extra little language provides. It gives the guidance on if that happens and you make that payment, you can go after the person who was supposed to pay it. You can go after them for that payment. That might be through small claims. That might be through a motion to enforce the judgment. That could be through a contempt motion. It just depends on the situation. However, if that language is not in there, your chances of protection are really, really challenging. Okay, so attach an extra sheet, make sure all the debts are in there and who's going to do what and how it's going to be done. Okay, and then the little handy dandy transferring of property and debts. This gives you a timeline of 30 days to actually accomplish these things being transferred. Okay, this includes titles to vehicles. So on that personal property sheet, you can include the VIN number. So where it says details of distribution, you can put the VIN number of the vehicle. That's really only necessary if your opposing party is refusing to sign a title. So this is what's called a self-effectuating judgment that basically says this judgment operates to convey title to the party awarded the property if the other party fails to comply with this requirement. However, it is very challenging to get the DMV to enforce that sentence, particularly if you said white Toyota to from grandma to me. They're like, what white Toyota? What are you talking about? Yeah, so you need to make sure you put the VIN number on there if you have somebody who's going to be unwilling to sign off on the title. And just remember, people kind of lose their minds during this process. So people who are really rational and reasonable at the front end of this might not be so rational and reasonable at the end of it. So if you can get a hold of the VIN number, that's always on your insurance cards, that's on your registration, that's in the glove box perhaps. Just jot that thing down, take a copy of the title, whatever you need to do, and just include that on the property sheet to help out with that transferring. All right, the next section, the former name. So when it says former name, I actually just had to research this for a client of mine. This means a legal name you have held before. So this does not mean you get to change your name to Mrs. Claus if that is not already a name you've held before. Okay, as much as you want to be Minnie Mouse, alas. So this is going to be a held name you held before. I always add the words if she or he so chooses, because you do not have to be forced to change your name. And if your former spouse is like, and I want you to get rid of my name, I mean, yeah, they can't make you. So there's that. Feel free to keep the name if you want to keep the name. And you also can't force them to change their name. So if you really want your family name to not be attached to that slime ball, too bad. You can't make it happen. But I always add those extra words if she or he so chooses. Okay. So in this little section 8, additional provisions, that's where you're going to slide in these extra pieces I handed out. You're going to mark those as exhibits. You can call them A, B, and C. That's fine. You can call them 1, 2, 3, 4. That is fine. Just make sure that they're in there. And then, of course, I guess I should probably. So you can do your provisions there, and you can just say additional provision. That you can say Exhibit 4, and then the title of it. Exhibit 5, and the title of it. That's perfectly okay. That gives somebody the notice that there's this additional piece attached. Okay. Moving on to the court costs and fees. Okay. If you are taking this general judgment by default, you had to have put into your petition that you wanted your attorney's fees or costs paid for. If that box is not checked in your petition, you cannot get it in your default judgment. That can actually give grounds for a set aside. Okay, so the default judgment has to mirror, or at least reasonably mirror, what you put into the petition. So it can't be some crazy thing where in the petition you're like, yeah, joint custody and 50-50 parenting time. And then the default judgment, it's supervised parenting time and sole custody to mom. Those kinds of things trigger the ability for the other side to challenge the judgment. Okay, we have to be reasonable. If you want to burn the bridge down, don't do this yourself. Okay. All right, now we're into the money award. This is another piece that becomes very challenging because the people looking at the money award is not the judges, it's the state, particularly if they're going to be enforcing these things. Okay, so in the money award, this follows through with the support obligation and what it includes. Child support, must be paid to the Department of Justice. This is that place of payment, right? This is saying, yes, Department of Justice, I want you to collect this money. You're going to write out who the petitioner is, who the respondent is, and the specifics that are required there. Just remember, it is not the full Social Security. It's not the full date of birth. It's just the last four of the social, the year of birth. But the one thing that does get missed if you have a lawyer, which if you have a lawyer, you will not be filling this out. However, if by chance you had a lawyer and you are filling this out, just make sure their telephone number is on there. That one gets missed quite a bit. And there's a nice little note here at the bottom. It says a party receiving a money award is the judgment creditor, and the party paying the money is the judgment debtor. You will also see the words obligor and obligee. This is very confusing. Why in the world they choose to do that, and how in the world that's 8th grade reading level, I do not know. However, the obligor is the person who has to pay. The obligee is the one receiving it. Okay, so you'll see that filtered like throughout the statutes there. It's not consistent. Just know that debtor, obligor, that's the person who's paying. Okay.
Is there a question?
Yeah.
Is that only for support, or is that any kind of other payments?
It's usually any other kind of payments. Also, it's like if you're talking like in a credit situation.
No, like a payment on just part of a property. Is that still under real property then?
For the money award?
Yeah.
So we're going to get to that section. That I think that's actually in here. So we're not quite there yet.
Okay.
Yeah. So we're going to talk about this because it's another little bee in my bonnet that I have about the equalizing judgment. Yeah, we'll talk about that. It's a couple of pages.
Okay, but this is just for support then.
So no, this is also for if you're going to be paid out a certain money award.
Okay.
So this is for a money award. So a money award is used when there is going to be a payment collected that we know the amount of. So if there's spousal support, child support, or what's called an equalizing judgment. And we're going to talk about that a little, we're going to touch on that just a little bit. So the property piece, that's not going to be in the money award unless you have a specific number. If you're going to be awarded $100,000, whether or not it sells for $105,000 or $17 million, if you have a set number, it can be in this as a equalizing judgment and in the property section. Normally, people don't have a set number like that. It's usually the house sells and you split the proceeds by a percentage. So, but if you have one, yeah, it can go into this. Okay. But that's in a couple of pages. So the child attending school, this one is if you have the kids section. It's
a whole other class.
It really kind of is a whole other class, and I just don't want to run this all the way to 7 o'clock. I'm already past my 40-minute timeline. Sorry, Ray. Okay, so the child attending school, that's in this little section where it says if an adult child is awarded support to be paid directly to the child, and there's no support awarded for minor children of the parties, or if the judge tells you that adult child is a judgment creditor, fill out this box. Okay. I mean, it's going to take like a graph to break down all the options there. What they're really talking about is a child attending school. Why they are not using that terminology, I do not know. But child attending school, that's going to be where you're going to put those things in if they're going to be getting support. If you've got the child support one, I'm sorry, the dissolution with children one. Okay, so moving on to the important section. So this is talking about who is paying who. Is the petitioner paying the respondent? Is the respondent paying the petitioner? And is it the same person the whole time paying things? Because sometimes spousal support might be being paid by the petitioner, but the respondent owes a certain amount for an equalizing judgment. It just depends on what's going on. So you have to really pay close attention to what's happening. So you fill out the little top section saying, here's who we are. And then it goes through the types of judgment. So the first one, if you have the child one, it's going to have the child support on there. You say who's paying whom and who's receiving. So they try to make it really clear so that the party filling it out understands what's going on. So you need to fill out each of these columns if you are getting that type of support. Each of these columns has specific information that is required in order for you to collect this support. Okay, so who's paying who, the amount, and then the start and ending, right? So these are all those super important pieces. So on this, we've got child support as an option. We have our spousal/partner support. And they're using the word partner support. This is only if you are in a qualified and registered domestic partnership that you can use the word partner support. If you are in an unregistered domestic relationship, you do not qualify for spousal support or partner support. So even if you've been living with a dude for 15 years, you guys share everything, sorry, you're out of luck. If you want spousal support or partner support, you need to get married. Unless you're, anyway. Okay, so then you write down. So then it's going to harken back to some of those things we saw before. What type of spousal support? Transitional, compensatory, or maintenance. Okay, so here on the section that talks about these different types, remember it's possible to have every type of support for certain durations of time. You could have transitional for 2 years, you could have maintenance for 5, and then you could have compensatory for 6, and you can mark down if they're going to run concurrently. If they're going to be running back to back, like transitional stops, you then transition to maintenance. All of these things are possible. And the court, in order to know about them, it needs to be on this sheet. Okay, so you're going to have your start and stop time of when this is expected and how much it's going to be for. Okay, and it is also possible that you do step down payments. So you might start with a higher amount because you might need a little bit more at the front end, but then as you get more self-sufficient, it's stepping down to less. Okay, so those are all going to be in there. There's a little ditty here at the bottom that says all payments end on the death of either party unless an earlier event is specified. Okay, so most of the time we have ends to our spousal support payments. It is possible to get indefinite support. However, it's not overly frequent. But if you die, you don't get support anymore unless you were owed money, unless there's arrears. In that case, your heirs actually could have a claim for that amount of money. So that little ditty right there is not really helpful because it doesn't talk about if there's arrears owed, what happens. So just keep that in mind. And I didn't provide you arrearage language. I mean, literally, I could have provided you like 17 pages of extra stuff you should be putting into this. But nobody asks me when they rewrite these documents on whether or not they're doing it right. So just know that if you are owed money when the payor dies or when you die, you are entitled to that money that was owed to you. Okay. All right, here's down to the property division. So this is a section where you might have in that list of personal property, and you have these values. As you go, you can start adding up like, wow, he's keeping the classic car collection and I'm keeping none of those. It is possible to have what's called an equalizing judgment. And this is where if one spouse is walking out of the relationship with more stuff of more value than the other one, you take the two values and you see what the difference is between the two of them, and then you divide that number by 2, and the person who's keeping more of the stuff pays that half amount to the person who's walking away with less. So if you have an equalizing judgment, that's where it's going to go in the document, where it says property. This is also where it would go if you have a set amount you are owed from something like real property being sold. So if you know it's $100,000, I'm getting my $100,000 in there. It's going to say your $100,000. It's going to say what it's for and what the terms are on the timeline. Okay, timeline is super important. So going through prejudgment interest, I literally never have to deal with prejudgment, but post-judgment interest is a different story. So by statute, these judgments, they accrue interest at, it's called either per annum, you might see that word, or you see simple interest. This means non-compounding interest. So what this means, if you're calculating interest, so say you're owed the $100,000, statutory interest is 9%. There's other scenarios, which we'll talk about in just a quick sec, but you take your $100,000 times 9%. That is the amount for the year. You then divide that by 12 to get how much it is each month. So because it's not compounding, we don't get to add that little interest payment that's owed to the $100,000 and then tack it onto the next month and then tack it on the next month. Too bad for us, right? We don't get to have that. Nope, it's going to be simple interest. So it makes it really easy to figure out how much is owed if you have back payments. So if he's paid support for 3 months, but not for the other 6, then it's the 6 months that's going to have this interest. And then you just, multiply that little number. It might be $15, multiply that by the 6, then that gets you to how much interest is actually owed. And at the end of the year, that doesn't just add on to the next year. It's its own individual year. So let's say for 2019, it was $347. Okay, for 2020, it was $500. That you're not adding that extra 3 to compound it. It's the 300 and it's the 500, so we've got 847, right? Whatever that math is. The other piece of this is if you paid debt for somebody. So if you pay debt for somebody, the statutory interest of 9% can be added on, or language I often use is whatever interest was being charged to you from the creditor, which might be 29.97%. It could be this horrible percentage rate. And if you paid that money, that's the rate you are entitled to getting repaid on. So it doesn't have to be just the amount you paid. It's, it's what's been accrued if this person hasn't been paying. So just kind of keep that in mind along with all the other 5,000 things I've told you about today. Doesn't have to just be that. All right, then we get our court costs, who pays those, and then deferred court costs. Okay, the final little tally end here. So this page has a certificate of readiness on it. This is driven by the Uniform Trial Court Rules. And what this is this is saying, court, we are ready for you to sign this. So this is going to say, this is ready for your signature. And then you have to select why it's ready for the court signature. If service is not required, that's only because there's a default. And that means you had a default order, they didn't show up, they didn't appear, they didn't file a document. That box gets checked, right? And then that also gives you some other scenarios that could be potentially in play, but not overly common. The next one is meet the stipulation. And remember that, so the law has changed. It is not required to have a notarized signature. It's just signature that says by penalty of perjury, you know that I'm signing this document. It does, though, need to be dated. Dated. Okay, Ray, looking at you. Dated. All right, so the next one down is the served. I've served a copy of this judgment. So here we're coming back to our service time. This is a little bit deceiving where it says 7 days, because in reality, it isn't 7 days. It also needs to include 3 days for mailing, which also includes emailing or faxes. So I just wish that it would just say the right thing, but it doesn't. So what you really have to do when you serve this document, remember that calculation starts the same way. Your computation starts the day after you served it, and it goes till 11:59 p.m. on the last day of your service window. So this actually requires 10 days. So it's 7 days for this type of document, plus 3 days for mail or email or fax. So it's really 10 days that you have to wait before you can file this with the court. So you send your draft document over to your former, soon to be former spouse, and they then have a chance to look at it, object, make any revisions they want, whatever. You don't hear from them after 10 days, day 11, go file it with the court. Okay? And then you're going to check these little boxes of no objections been served on me. I received objections that I couldn't resolve. And so then it's going to ask for that's going to trigger a hearing, and then conferring about objections, blah, blah, blah. And then you have to write your certification of what date and time, the address you sent it to, If you know your spouse no longer lives at the address you put on this document, and he knows that you know that, that is grounds for a set-aside. Okay? Do not do that. If you actually know the person's address, even if it's not reflected on the court's docket, do the right thing, take the high road, and put the real address on. Okay? There's lots of ways to try to screw over people who have hurt us, right? This is not the way to do it, because an attorney will get hired and we'll just get it set aside, and then you're going to look like a real donkey. So don't do that. Okay, so you then submit this. Okay, so you need to make sure if it's signed, that it's dated. Signed and dated. If this is stipulated, that requires your other side's signature and also the date that that person signed. Okay? If you've got a kiddo as part of this, then that's also part. And then on the ones that have the children's, it's going to have this section for the optional application for child support. Child support does not just automatically happen. There's not like child support fairies that like, oh, a judgment got fired, and oh, here, I'm going to do this. No, you have to apply for it. So what this is, new language that's now part of the judgment. This will trigger, if you fill this out, this will trigger the DOJ to actually do the application and start child support. It's a really so happy they changed this. This is like 2021, I think, is when they added this extra language. So super handy. Fill that out if you've got kids involved. Okay. So to deal with our kids section, so anybody who doesn't have children, of course, is free to leave. But Melanie, do you want me to go to the kids section?
Yeah. Does anybody want to leave, or does everybody want to listen to the phone information? So I'll have to escort you out of the building if you'd like to leave. And I would ask if you would mind filling out a survey and leaving that behind. That would be fabulous.
I have one question before I leave.
Yes.
Depends
on how general it is.
It's general. Is just what? So once I filed the petition, he's getting served. Then how long do you have for the judgment?
So what do you mean? How long do you have for the judgment?
I mean, so once you served in the petition.
So that's the 30 days. So he has 30 days to file his response.
Yes, for the petition.
To the petition, yes.
But then after that, doing the judgment, how long do you have then?
You have kind of however long you want. So you're going to be set for a trial date. The trial date, if you guys end up settling before that, it's really just going to depend on when your trial date is. But if you guys are working together and are able to come to an agreement, you can fill out the judgment whenever you want to.
Okay.
Yeah. And then the two of you just end up signing it. And you don't have to sign it at the courthouse. There's a lot of people who are like, oh, he couldn't get off of work, so he couldn't make it. No, man, just get his freaking signature and then come down yourself. Like, that's perfectly fine.
You're talking about if he didn't file a response?
No, if he files a response, but I'm just trying to figure out like timing here.
Yeah.
So once the response is in, then there'll be a trial date. It's just set.
Yeah, trial date ends up getting set. If you don't have kids involved and you're not asking for spousal support, you actually have to go to arbitration. So that's for mandatory arbitration. So you would get set with an arbitrator, and then you'd have to pay the arbitration fee, do arbitration, they make a decision, and then you go forward from there.
You go with the judgment.
Yeah. Yeah.
I also set right now about 3 to 6 months out.
Yeah.
Thank you. Okay, that helps.
Yeah.
Thank you. This has been helpful.
Oh, yeah.
Thank you so much.
Okay, so to our kids section, so this is going to be your page 2 of your packet. So this is going to talk about who your kids are and their year of birth and their age. Okay. This is all pretty self-explanatory unless you have a kink in the works, which is the kid is not the father or their paternity has not been established. If the kid is not a child of this relationship, do not include them. Yes.
What if they were legally adopted?
Then they're a kid of your relationship.
Oh.
Yeah. Adoption makes that kid your own. Yeah. Okay.
For sure.
There's, of course, several other ways. There's a few other kinks that can happen in this. We're going to keep this fairly general. So if you are pregnant and you are getting divorced and that kid is not outside of your body yet, not a part of the judgment, okay, that kid has to be on the outside of your body in order to be part of the judgment, okay? So that opens a little bit more of a can of worms. However, cannot be included. They have to be on the outside, okay? So then you're going to mark whether or not the party is pregnant. That does need to, in fact, be marked because, so say you are pregnant and then it's not talked about, it's not discussed. It just causes issues. So just mark the box. Either you are or you're not, okay? And then you keep walking through. It's the survey. Okay, so then you keep walking through this. This is talking about the custody jurisdiction. So if you are tempted to mark the box that Oregon does not have jurisdiction under the UCCJEA because there are very few reasons that Oregon would not have jurisdiction. But one example is if you have a protective order in a different state and you have moved here and in that protective order in a different state awards custody and parenting time to one of the parents. You are going to need to deal with that. And most protective orders in most states, they do expire. So it's possible you might be up against expiration date. It is pretty rare to see this, but it does happen occasionally. So if you had been in an extended separation and there's a separation document in a different state and then you moved to Oregon and you want to turn into a divorce, there's some scenarios. However, it's pretty rare. So if you're checking that box, I highly recommend that you talk to an attorney because there could be some additional steps that need to be taken. Okay, so protective orders, prior judgments of separation, those are kind of the only ones. Guardianships might be also part of that list. So something that was in the packet that I did not explain to the people who just left, but that's okay. It's in their packet. Hopefully they took it. Is the statutory language for inclusion as an exhibit under additional provisions. You can insert this kind of wherever you want to. What this language is all the language that's missing in the state's judgment that's actually required by statute. So the first couple of pages of these these judgments are called findings. And these are just stating the facts for the court. These are just findings of the court. And then it goes into the actual document that's the judgment. So this additional documentation are protected statutory rights that we have, terminating things like your ex being named in your will and your ex being named in your trust and as the beneficiary on a retirement account. What if you didn't change that? What really happens? What this language does is it triggers those protections. It also terminates your ex's authority of if you have a power of attorney or if you have given them agency over you in some other document. So without these things in there, it won't be super clear. So this language, you can just add it in as one of your exhibits, will give you that protection. And this is actually required statutory language. And so I was a little bit surprised to see the February 23 version didn't have this language built into it. A little disappointed, but I actually put in there which ORS is being referred to in case you want to take a look at it. Okay. So for that little section, that's the way the handout is in there for. All right, then we go into custody and parenting time. Custody, I'm going to keep this pretty direct. Custody is about decision making. Okay, this is who's making the decisions for your kids in the categories of medical, education, and religious training. And it's also usually the person who has been making those decisions for the kids most time. Occasionally, I will have people who genuinely split those duties 50-50, but it is very rare. There's usually one person who's the default go-to when things have gone sideways, right? Parenting time is about the time you actually get to have with your kid. This is about the schedule. So people conflate those two and they'll be like, oh, I want 50-50 custody. So if you are using a percentage, it is not about custody, it's about parenting time. Because in Oregon, we have 3 types of custody. We have sole custody, which means one person is where the buck stops. They make the final decision. We've got joint custody, which means the parties have to agree on these decisions. It requires kind of a good relationship, okay? And the court can't order joint custody, so the two of you just have to agree to joint custody. And then we have the non-custodial parent. Even though it's not technically, a form of custody, there's tons of protected rights. And unfortunately, this document does not list what those rights and authorities are. So get your pen out. I'm going to tell you what statute you need to go to. So it's ORS 107154. So this is the authority that non-custodial parents have. And it's a whole list of things. They're allowed to talk to schools, talk to medical providers, get documents. Heaven forbid your kid's in trouble, but if they are, it allows them to talk to corrections facilities and, whatever. So because somebody doesn't have custody doesn't mean that they don't have parental rights. And those are terminology that you see get screwed up a lot. And people get really kerfuffled about not having custody. Like it means it's like some black mark. Oh, they lost custody of their kids. Yeah, man, it's in Oregon. Really only one of you is going to have custody. So yeah, just if your spouse or your soon-to-be ex is really uptight about the custody issue, just try to let them know it's just about decision making. I'm not taking you away from your kids, right? Parenting time is about that. All right. So the parenting plan. So it would be very hard to put an actual parenting plan into the 3 lines that are provided. So you're going to want to attach a sheet. And I really encourage people to take a look at the Jackson County Standard Parenting Plan just for ideas, even if it's not what you want to do. And genuinely, if this goes to court and you have trial, a third party who does not know you or your children is going to be making a decision about what works for your family. Like, that sounds terrible. I mean, they're not there having to pick up kids from soccer practice at the same time that Jimmy gets out of violin. And then that's when you're supposed to be, quote, exchanging the kids at the Fred Meyer parking lot. I mean, come on. So the more you can work together with your co-parent, the way easier it's going to be for you to actually come up with something that's going to work. Okay. And sometimes that's not going to be possible because people get divorced for reasons, right? All right. So the parenting time, you're going to put that section in there. You're going to make sure that exhibit gets attached. If you are doing a default judgment and you mark in this judgment for supervised parenting time or no parenting time, and it was not pled for in your petition, your judgment will get tossed. Not necessarily immediately, but if it gets challenged in the first year, there's a very real possibility. So you need to make sure that if you are wanting something really extreme, like supervised parenting time or no parenting time, it's in your petition and you give the reasons why. Okay? Gives you some extra protection. All right, relocation. I'm really happy they added some extra information in here. Now they actually include the statutory language and then the next piece. This is a new addition I appreciate. So statutory language, it requires that you provide this notice if you're going to move greater than 60 miles away. The word reasonable is not defined in the statute. That doesn't mean it's 60 days if you're moving 60 miles. That's not what it means. It just means that this person who you are co-parenting with is going to be reasonably aware that you're moving. Okay. And then you need to provide a copy of that to the court. If you're checking the box that says relocation is suspended for good cause, this needs to be in your petition. If you want this provision waived, you need to put it in your petition. Okay. The contact information going down, I wish they put the or between these two boxes because it is one or the other. It is not both, but it has to be one, right? It's one or the other. Either good cause exists or you're going to actually give the check mark. So this is on page 4 of if you've got the kid one. Oh, you don't have the kid one. Oh, then it's, yeah, page 4. So the good cause that exists for the contact information, again, has to be in your petition. Good cause is going to be things like domestic violence. It's going to be things where you might have a protective order. There could be a no contact order. Those kinds of things are good cause. Otherwise, the court is pretty hesitant to allow people to not give up their information to their other parent. So if that parent has the kids, the other parent deserves to know where the heck they are. Yes.
These. So relocation, does a parent have to be moving like right away, or if it's something like, oh well, maybe I'm thinking about it in a year or two, like, can they still mark it and have that already in there just in case, protect them in case in the future they want to move, or is it that they have to be thinking about moving in that like right after divorce?
Well, so the only way to waive the relocation provision is if there's good cause. It's not just that you're thinking about doing it. It means that there's a reason for it to not be required. So things like domestic violence, things like, harassment and crimes against you. Otherwise, you have to provide notice when the time comes. So you don't need to give like 2 years advance notice. But the default is going to be that you have to provide notice of relocation. Yeah, I mean that's just the best that I can answer you to give you a general answer.
And the other question was, if they must provide each contact address and contact telephone numbers. What about if they only want to provide phone numbers, not contact address? Like right here it says both, right?
Yeah, it's supposed to be both according to the statute. But if the two of you are in agreement to just exchange telephone numbers, that's fine. It's just that if one of you decides to not be agreeable, the statute's the default, which says your address is required.
I'm just thinking of like domestic violence that like somebody does. I'd rather not have the other partner know like where I live, but I want them to contact me in case of my kid is with them.
Sure.
And they get sick.
So that's the piece where it triggers the good cause. So that second line down that says good cause exists to suspend the obligation to provide that information. That could be a situation where that box is checked. You just need to make sure it's in the petition that you want to have that language added. So, I mean, there's all different kinds of scenarios. I mean, if there's already an existing protective order, then that protective order language is going to be the piece that you're going to want to defer to, even though the general judgment replaces it. But
I'm wondering if that's something that can maybe be placed like in the parenting plan where the children get sick, they would need to notify each other.
Absolutely. Yeah, and that's actually very standard in parenting plans. In case of an emergency with the child, that the other side is notified as quickly as possible. Yeah, so sickness, injury, trips to the hospital, those kinds of things. And then the parental authority. So this one is, so remember I told you guys that statute, the 107-154. So that's the parental authority that if you are, quote, suspending that for good cause, you have to plead for that. And if this goes to trial, the court would have to order it. Okay, I'm taking all the time. All right, then we go into the child support pieces. You are going to want to read through this and make sure that if you have an existing child support order, that you note it. Because what we're going to do with this, and I'm so happy to see this language, is that this general judgment is going to absorb that child support order. Okay? Because the state has finally figured out that oh my gosh, having all these dangling case numbers, because the child support case numbers are not the same as the domestic relations case numbers, that they now, so you're going to notify that, say, yep, here's the case number, and then it's going to be absorbed into this general judgment. Okay. As we walk through this, I'm not going to walk you through each of those boxes, but just make sure that you are reading this and before you check the box. And if you check the wrong box, if you have whiteout, use whiteout. If you don't have whiteout, put a line through it, do a little initial next to it, and then do a check mark at the one you actually want. Okay, you don't need to like do a black scribble out or something like that. It can just be a single line. There are reasons to waive child support, and this kind of gives you some ideas of what those reasons are. And then the child support calculation. I know that the gals down here probably do child support calculations all day long. Feel free to hop on the child support calculator. Just put in the state of Oregon child support calculator and have a good time. Check it out. There's, it's going to look at remember, it's your gross monthly income. It's not your net income. And if you make no money, you don't get to mark 0. You get imputed at full-time minimum wage. Jackson County just moved at the beginning of this month to $13.50 an hour. And that's for 40 hours. That's how the state calculates it. So the lowest we have here in our county is $2,340 a month. Even if you're not making that, if you want to be attributed something else, you actually have to plead for it. Okay. Which makes it a little bit more challenging if you're doing this on your own. You're going to want to make sure your child support calculation worksheet is attached, and you're going to walk through about who's paying who and how it's going to be done. And then it goes into the medical. So something that I noted on this, so I highlighted health insurance coverage. Make sure that if the kids are covered in health insurance, that you mark who it is that's responsible for that. If they're not on OHP. Okay. Cash medical. This is only appropriate if people are not, if they're not splitting costs like out of pocket. And even then, the state does not enforce cash medical. They only enforce the baseline amount. So it just makes it a little bit sticky. So just a heads up on that. In the uninsured medical expenses, there's 2 boxes. One says uninsured medical expenses are not awarded. And then it says, or the other box. That means you have to pick one. Okay, if there's an or, you pick one. So in this little, I made a little highlight. In this little doohickey here, it talks about what's not included on this 50-50. What's not included are copays. Okay, if you have a high copay, you might want to start negotiating with your other person who's paying support and consider doing either an upward deviation, but take that into consideration when you're thinking about the split. It doesn't have to be 50-50. If somebody is paying the copays and they can't be reimbursed for them, maybe the split for the out-of-pocket needs to be 70-30. Maybe it needs 40-60. Okay, so just some little extra pieces to think about where kind of you get nickeled and dimed on that $20 copay. Income withholding, we talked about that. Place of payment. I was so happy to see. Okay, so on the child attending school, the child who's attending school, they have a whole list of criteria that they have to fulfill to qualify. And the statute, I think, it's not even listed in here. I thought it said the statute. Oh, it does. Yeah. 107108 is the statute for over 18 and under age 21 if they qualify. It's worth it to take a look at that. But this doesn't automatically just go to the kid if they suddenly become 18 and they're a child who qualifies for attending school. They have to take steps. Okay. So the kid needs to provide information to the state or to their person paying them about their enrollment and fulfilling the criteria. So you need to make sure you read through that statute so that they're in compliance. And then you can actually have that payment deferred to you if the kid is still going to be living with you at home. And there's a few ways to do that. I'm going to give you some numbers. Okay, are you ready? I know everybody's getting glazed over. Okay, hang on. So this is where you see in caps it says good cause exists not to pay the support directly to the child, and then it says different payment stuff. So this is the statute it's talking about. It's OAR 137055 410 subsection 4. Oh, I'm sorry, 5110, not 4. I don't know what I was thinking. Yeah. Oh, sorry. 5110 is the last 4 numbers there. A subsection 4. This is where the kid can sign off to have it go to mom or dad, whoever they're living with. But or the judge can order it. So if you want that payment to go to you, you need to plead for it. But it is possible, particularly if they're going to be living at home with you anyway. I know them getting half of the support award and then not paying half of the mortgage, that's not very fair. So those are ways to do that. And I was so happy to see that language put in there. Tax dependence. This is a very hot topic that people really want to know words on. Our court here, they will defer consistently to the IRS rules because the feds do not give a crap what the state of Oregon does. They don't care. IRS, they are going to apply their own rules and their own rules only. They do not kowtow to the judgment in the state of Oregon. So if you guys agree to do something that's not copacetic with the IRS rules, and then there's a dispute later, IRS rules are going to win. Okay. So there, I highlighted this new little info. Parties are advised that this judgment is not binding on the IRS and will not provide a defense if the parties fail to comply with IRS regulations. The two of you can agree to do whatever the hell you want to. You want to split it 50-50, you want to claim the kid this year and him claim the kid next year, fine. That's totally fine. But if things hit the fan and this judgment has to be enforced, the courts are going to be like, nope, sorry, not doing it. The IRS rules prevail. I haven't challenged how much money they should be entitled to, but I might have a case here coming up. I might need to do that. And then the life insurance piece I went into. Okay, so that covers the information in the judgments. The biggest pieces here, please read the lines. And if you need to take a break while you're reading through it, do it. Take the break because stuff that gets missed becomes a real problem if you have to try to go and enforce it. Okay?
Thank
All right.
you, KJ.
Yeah.